Welcome, I'm Russell Alexander. I've been a lawyer with the team here for over 20 years. We help families going through separation and divorce. Without further ado, let's get into today's topic. Here's the law on admitting facts. From the standpoint of legal procedure, formal admissions are simply a litigant's statement that acknowledges as a particular fact as being true. For example, a family litigant can provide an admission to the court that for the purposes of the divorce proceeding with respect to his or her spouse, the date of separation was on a specified date. In a recent Ontario civil case, some of the general principles about tendering and withdrawing admissions were the focus of the Court of Appeals analysis, and they have equal relevance to family law matters. The simple moral of the story is this: be careful of what you admit to. In this recent case, it involved a patient's claim against an emergency room doctor for medical malpractice. The key issue was the trial judge was whether the doctor breached the standard of care expected of her when she provided the patient with an on-the-spot medical diagnosis and emergency treatment. The trial judge was asked to consider a document called Admissions Made by the Defendant Doctor. In advance of the trial, it had been inadvertently released by the doctor's own lawyer to the patient's lawyer, who refused to consent to its withdrawal. From the standpoint of proving malpractice, the document contained certain damning admissions by the doctor about her assessment of the patient's medical issue. Although it was a formal admission of fact, the trial judge ultimately discounted it as untrue and went on to dismiss the patient's claim entirely, after concluding the doctor had indeed met the requisite standard of care. The patient appealed successfully. If you're enjoying this video and find it helpful, please give it a thumbs up or leave a comment for us below. Although the trial judge has the freedom to interpret what an admission means, the appeal court cautioned that the interpretive exercise cannot morph into an analysis of the veracity of the admission. A formal admission is conclusive of the matter admitted. Moreover, the judge was bound to act on any formal admissions that were presented, even if other evidence contradicted them. Here, the trial judge had expressly found that in the context of this medical malpractice action, the doctor's unfavorable admissions related to pure facts. Nonetheless, the judge had gone on to essentially weigh those admitted pure facts against other evidence led at trial. He then proceeded to effectively permit the withdrawal of the admission on the basis that it was not accurate. This was contradictory and an irregular approach. Having concluded that the manner in which the judge treated the doctor's admissions resulted in an unfair hearing for the plaintiff, the Court of Appeal ordered a new trial. One added point to note in drawing its conclusion in this case, the Court of Appeal adverted to its own prior ruling in a 2009 family decision called Sierra, which clarified a concept a court bound to accept the veracity admissions of pure fact, but is not bound to give effect to an admission of law, or mixed facts and law. In all the circumstances, interests of justice dictate that the issue should be determined at trial rather than by way of an admission. To learn more about this case, you can read the full article in the link below. Please give us a thumbs up if you like this video and have found it helpful. You can also subscribe to our channel and hit the bell icon to get notification every time we upload a new video. Thank you for watching.